Hello guys, let me introduce myself. My name is Gaberiel Hutauruk. I'm from rombel 9 and today we're gonna talk about Ghana criminal system. First of all, we're gonna talk about foundations and legal pluralism. Ghana's criminal justice system is a profound expression of legal pluralism, built upon the historical foundation of English common law. Inherited from its period as a British colony or Gold Coast, the supreme legal authority, however, rests with the 1992 Constitution, which guarantees fundamental human rights, fair trial principles, and the independence of judiciary. Criminal law itself is almost entirely codified in two key stages: the Criminal Offence Act 1960, Act 29, which defines the elements of specific crimes such as murder, theft, and assault, and the Criminal and the Other Offence Procedure Act 1960 Act 13, which governs all procedural aspects from investigation and arrest to trial procedure and sentencing. While customary law is formally recognized in Ghana's legal system, its direct application in the formal criminal domain is minimal, primarily influencing matters of land, family, and minor civil disputes. Nonetheless, the informal system of customary justice can play a mitigating role, often functioning as a first point of conflict resolution in local communities, which can reduce the number of cases entering the formal court structure. The second one, we're gonna talk about institutional pillars and their roles. The effective functioning of the system relies on the coordination of several principal institutions, each with distinct constitutional mandates. The first one is Ghana Police Service or GPS, the primary law enforcement agency. The GPS is responsible for crime prevention, maintaining public order, and the detailed investigation of offense. They are the initial point of contact between the state and the accused, carrying out arrests and the compiling the docket of evidence. The efficiency of the GPS is critical, as delays in investigation are a major contributing factor to the backlog in the courts. Number two is Attorney General's Department or AGSDAP. As stipulated by the Constitution, the Attorney General is the chief legal officer and holds the exclusive power to initiate and discontinue all criminal prosecutions. The AG's department often works through public prosecutors to manage cases in the lower courts, ensuring that only cases with sufficient evidence proceed to the trial. Number third is the judiciary, the adjudicatory arm, organized hierarchically from the district and circuit courts up to the High Court, Court of Appeal, and finally the Supreme Court or the highest appellate body. The courts determine guilt beyond a reasonable doubt in accordance with the principle of adversarial justice, ensuring the protection of the accused person's right at every stage. Number four is Ghana Prison Service or GPS. This correctional body is tasked with the secure custody and rehabilitation of convicted offenders and those awaiting trial. The prison service face immense pressures due to chronic overcrowding, which severely limits its ability to execute effective rehabilitation and reintegration programs. Number third, procedural guarantees and right of the accused. A core feature of Ghana system is its commitment to constitutional rights protection, a necessary guardrail against potential stage overreach. Key rights afforded to any accused person include: the first one is the right to liberty. An arrested person must be brought before a court of law within 48 hours. Failure to adhere to this time frame can lead to a habeas corpus application for immediate release. Number two is the right to bail. For most non-capital offense, the accused has a constitutional right to be granted bail pending trial, subject to conditions set by the court to ensure their future appearance. Number three, the presumption of innocence. The burden of proof rests entirely on the prosecution, which must establish the accused's guilt. Beyond a reasonable doubt, the accused is not required to prove their innocence. Number four is the right to legal representation. If an accused person faces a potential sentence of death or life imprisonment and cannot afford legal counsel, the state is mandated to provide legal aid. Number four is systemic challenge and the imperative for reform. Despite a robust legal framework, the Ghanaian criminal justice system is plagued by deeply entrenched systemic inefficiency and resource of deficits. The most critical issue is prison overcrowding, driven overwhelmingly by the high number of remand prisoners, those awaiting trial who can spend years in custody. The situation is the direct result of slow investigation. Police inefficiency and lack of resources often lead to prolonged investigation, delaying the submission of dockets to the AG's department. Number two is judicial backlogs. An insufficient number of judges and courts, coupled with poor case management practice, cause significant delays in the trial process. Furthermore, corruption remains a persistent threat. Concerns about low-level corruption within the police and even segments of the judiciary undermine public faith in the impartiality of justice. Another major challenge is the underutilization of non-custodial sentencing option. While the law permits alternative sentences, courts often default to imprisonment, exacerbating the overcrowding problem. Current reform efforts are thus focused on determination and diversion, encouraging the use of alternative dispute resolution or ADR mechanism for minor crimes to reduce the caseload on the formal courts. Second one is judicial case management, implementing technology and best practice to speed up trials and reduce the demand population. Number three is capacity building, investing in training and resource for the police and prisons to service to enhance efficiency and uphold human rights standard. In conclusions, Ghana's criminal justice system is a framework of high constitutional ideas that is frequently strained by socio-economic realities, demanding continuous and focused reform to bridge the gap between its legal mandate and its practical execution. Thank you for hearing me.